assets. The moderator is going to be Ming, Shao, Senior Executive Vice President and General Counsel for MicroStrategy. And the panelists are Hanse, who's a partner at Perkins Coie, Neel, Maitra, a partner at Dehcert, and Amy Park, a partner at Deloitte. Welcome.
You guys ready? Hello, my name is Ming, Shao. I'm the General Counsel at MicroStrategy. Welcome to the Regulatory Roundtable. When we were backstage just now, about ready to come out, I was thinking, when you're a lawyer or an accountant, as we all are, and you're about to conduct a discussion on regulatory topics in the middle of the afternoon, after people have just had a big lunch probably, I don't know who put us in this slot, you sometimes get concerned that regulatory topics are going to cause sleepiness in the audience. But you know what? I don't think that's going to be a problem today. And the reason is that the topics that we're going to talk about are some of the most exciting and consequential to the digital asset industry which have taken place to date. And many of these topics are topics that all of you have read about in the general press. You certainly heard about some of them here at this conference. Think the SEC's recent approval of spot Bitcoin ETPs, right? Think about a topic that we talked about with Amy last year, which came to fruition at the end of 2023, which is the adoption of new rules that effectively fix, to a large extent, some of the problematic accounting treatment of Bitcoin held on a corporate's balance sheet. We're going to be talking about issues that are very much undecided at this point, but when they do get decided, are going to have a tremendous impact on the digital industry. Think the SEC's lawsuit against Coinbase or Ripple. Sure. Think about the SEC's review, which is currently underway, regarding the application for spot Ether ETPs, right? A lot of really consequential things going on. And I'm hopeful that we're going to have time near the end of this discussion to talk more generally about legal considerations that face businesses which are interested in starting or conducting, say, Bitcoin-related application businesses. Because the environment there, the regulatory environment, is becoming in some ways more challenging for them, not less challenging, even though there's been some progress and clarification in other ways, right? So very exciting agenda, and to help us understand these topics, understand where they're going, we've got up here 3 experts, and they're just not any experts. I've invited them to this panel because they constitute the core of the external team that has been advising MicroStrategy, in some cases from the beginning of our Bitcoin strategy. And you're not going to find, I think, more engaging expert participants in this discussion for these topics than these 3. And so I want to introduce briefly each one of them because I think it's important that you understand their background so that you can understand better their perspectives that they bring to these topics. The first is Neel Maitra, sitting here to my left. First of all, congratulations to Neel. He just moved to a new law firm, Dehcert. Thank you. Based in Washington, D.C. Neel has been sort of my go-to advisor on what the SEC is doing and what the implications are for our Bitcoin strategy and for Bitcoin generally. Prior to 2022, when he moved into private practice, Neel was the senior special counsel and crypto specialist at the Division of Trading and Markets at the SEC. Given the number of SEC matters that we're going to be talking about today, I'm pretty sure everybody's going to be very interested in what Neel has to say. So welcome, Neel.
Thank you.
Next up is Dax, partner at Perkins Coie. If there is an OG crypto attorney, Dax is really that person. He started advising on digital assets pretty much from the very beginning in 2010 or so. He's currently the head of Fintech practice at Perkins Coie. Thank you so much, Dax, for all of your support over the years, and thanks for being here.
Thank you.
And then finally, we have Amy Park. She's a audit and assurance partner at Deloitte & Touche, LLP, in their blockchain and digital assets practice. She's also spent time as a practice fellow at the Financial Accounting Standards Board. Like Dax, she's also been alongside MicroStrategy from the very beginning. So thank you, Amy, for being here, and thank you for being in a discussion with a bunch of lawyers. So thank you. I want to start off this discussion with what I think is the biggest regulatory development that's occurred since our panel last year, and that is the big legal domino that fell in January with the SEC's approval of spot Bitcoin ETPs. And I want to start with Neel, because Neel, you were at the SEC for some of those years that led up to the SEC's decision. And I want to ask you, was this a grudging approval? Was it just good news for Bitcoin, or can you see some good signals in there for the digital asset industry generally?
Thank you, Ming. It's wonderful to be here back at MicroStrategy 2024 with you and my fellow panelists. And before we get too happy, let me quickly answer your question and say, yes, it was grudging, and it is just for Bitcoin, and it's not good news for crypto generally, or at least I wouldn't read it that way. And I think, a couple things to bear in mind. Firstly, the SEC spent a whole lot of time rejecting these things, these Bitcoin ETPs, spent about 6 years rejecting these things before they finally got taken to court. And they got taken to court because they'd allowed some Bitcoin futures ETPs to sort of go live. And people started saying, well, if the futures products are okay, why are the spot products not okay? And the DC Circuit kind of agreed with that. It said, these markets seem to be pretty closely correlated. Why are you letting the futures products go ahead and not the spot? And it didn't say you have to let the spot go ahead, but it did say you got to tell us why, or you got to substantiate your decision. And even when the decision went back to the SEC, I thought that they'd still reject the Bitcoin spot ETPs, but they didn't. They went ahead and approved. But when they approved, and bear in mind that this was a 3-2 vote, like the two Democratic commissioners other than Chair Gensler dissenting, and what Chair Gensler said when they approved it, Chair Gensler issued a statement, and he said, fine, we issued it. We had a court decision that kind of forced our hand, but bear in mind that firstly, unlike other commodities, Bitcoin can be used for many illicit purposes. Not quite sure why that was relevant, and then the second thing, don't read this as being approval for crypto assets more generally. So to summarize, very grudging, very limited. Not good news generally.
I'm glad you mentioned Chair Gensler, because there's just so much discussion and speculation around him. He was, in a way, the tie-breaking vote, right? Yeah. Because without his vote, it just wouldn't have been approved. What does this say, in your view, you were at the SEC, about Gensler's true colors when it comes to Bitcoin and crypto generally?
That's a really interesting question. I think a couple things. I think firstly, a lot of people say that Chair Gensler sees Bitcoin as being different from other crypto assets. Now, I don't know whether that's true or not, but I think that there was also certainly the force of the court decision. It's a pretty clear decision, and it says 99% correlation between futures and spot. Why are you continuing to hold these back? That, plus I think there would have been several voices in the staff sort of saying, the markets are pretty well developed now. Why are we continuing to hold back the product? So I don't know what the precise lever was, but some combination of these factors probably led to the approvals. And I think the one thing to bear in mind also was how the SEC did the approvals, not just the fact that they did them, but how they did them. And they said, we don't want one fund getting approved and sort of sucking up all the money in the market. So you saw, I think about 11 Bitcoin ETPs approved at the same time. So that's really how this kind of happened, I think.
You mentioned correlation with the Bitcoin futures ETPs, and I keep thinking about the Ether applications that are out there, but we'll get to that in a moment. The Grayscale case that you talked about and the SEC's review process of the spot Bitcoin ETP applications really put a spotlight on how these Bitcoin trading markets work. I guess I want to ask Dax for this, because he's been around for probably the longest in the digital asset space among us here. What does the approval of the spot ETP say about the maturity of the institutional ecosystem around BTC?
I think that, Ming, for sure what it says is that from a regulatory or regulator and a market perspective, that Bitcoin is finally safe for retail investors, right? That people have been accessing Bitcoin through the unregulated spot markets for many years, but there have been Bitcoin ETP applications going all the way back to the Winklevoss application, I believe in 2013. And so we've been more than 10 years waiting for approval. And for many years, the SEC really rejected those applications. And one of the bases of rejection was that the surveillance, the market surveillance was inadequate. And I do think that personally, the fact that BlackRock has entered the space, Fidelity, WisdomTree, other public investment management firms have come in, but bringing the heft of those entities like BlackRock into the space really just, I think, gave everybody confidence that there is a market that can be safe, that there's tools for addressing the fraud and manipulation, and notwithstanding Chair Gensler's comments that there are issues with Bitcoin, that it can be policed. So this is a big deal, and it really does provide some legitimization for the space and a lot of validation for the pioneers in the Bitcoin space.
Neel, as a former SEC attorney, what is your view? Do you have anything to add to that?
I got to agree. I got to agree. I think there's 2 points that I would mention. Institutionalization, but specific benefits. I think it clarifies certain standards around things like custody. For example, each of these products has a custodian, has sort of publicly stated how it custodies these products and sort of takes steps against loss. More importantly, I think, look what this does. This approval sort of ties the traditional securities markets to the crypto exchanges. It creates a link between them because the products trading on these exchanges, these ETPs, they have to go to Coinbase, they have to go to Crackdown, they have to go to Gemini, other platforms to kind of source their Bitcoin. And so to that extent, they're tied, and that sort of creates a way forward for, well, not quite regulation, but certainly for greater surveillance, greater linkaging between the regulated and the crypto markets.
Yeah, it's fascinating you mentioned Coinbase, and we know that the SEC has a lawsuit going on against Coinbase, and we'll get to that in a moment. But in this context, I can't help but think about Ether, right? A lot of people who are Bitcoin supporters are also following what's going on with this Ether ETP application, right? Because if it gets approved, some think that maybe money may flow a little bit out of Bitcoin into Ether, at least temporarily. And I think a couple of weeks ago, or maybe a few weeks ago, people were generally thinking sort of plausibly that maybe Ether is going to follow Bitcoin in that regard, right? But just recently, maybe in the last few days, we've heard about some things in the news that sort of cast doubt on that, right? And there's the consensus lawsuit now against the SEC, and we found out about the Wells notice that they had received, I think, in early April sometime. What is your take on this? What's going on?
Well, I'm a lawyer, so I'll never give you a clear answer, but the Ether ETPs are going to be denied. They're not going to make it. At least, they're going to be rejected this time around. And I think the SEC is lining up to reject the Ether ETPs. We can speculate on what the reasons are, what reasons it's going to put forward. I am pretty sure that any denial will sort of be challenged by the sponsors and others of these products. And I think that the SEC will put forward some decisions of some reasons for its decision. But in reality, it's going to be the thing that's at the back of the SEC's mind is, if we open the door to Ether, what else could come through? And there are distinctions between Bitcoin and Ether. Like, there's not an identifiable founder or a group of founders. There are distinctions about not having a foundation sort of associated with Bitcoin in the same way that there is with Ether. The sort of the information asymmetries that the SEC sometimes talked about. But I think the key is, the SEC's inarticulate premise is, if we open the door to Ether, what else could come through? And so I think Ether is going to be denied.
Well, that's a very strong view and a very strong prediction. I know that in preparing for this panel, I was talking to Dax yesterday. I think, Dax, you have a little bit more of a nuanced view on this, and so it'd probably be a good counterpoint to share if you could.
Sure. I mean, look, I think that the SEC may very well reject the Ether ETP, but when it comes right down to it, it's really hard on a legal basis to distinguish Bitcoin and Ether based on the guidance that the SEC has given us, right? Mm-hmm. And so all I'd say is that like it is a big deal to deny Ether on the basis of what it is. We talked earlier about the market and like the surveillance of that market, right? And so the Ether market obviously is lagging in time from Bitcoin because it came later, right? But if you're looking at the asset itself, if you just review the SEC's 2019 investment contract framework, without any weighting, by the way, from the SEC, you could reach a conclusion that Bitcoin is a security and Ether is a security, right? And you can also maybe reach a conclusion that neither of them are, but more likely that all of them are. And so then it just comes back to reading the tea leaves. I think as Neel pointed out, I agree with Neel, that there are some differences in how Ether is structured, right? And just the fact that just in the last couple of years, Ether has moved from a proof of work consensus method to a proof of stake, and that actually influenced the rate of issuance of Ether in terms of its supply, that there is a group of people who are, to some extent, at least leading the development of Ether, right? And this is very much a decentralized protocol, but with Bitcoin, even though there are core developers, there have been fewer changes made to the Bitcoin, so the overall infrastructure. We heard some of the different proposals have been made to Bitcoin. Yes, it's becoming more efficient, but it hasn't been widely changed as much as it has with Ether. So I think it's hard to tell here, but Neel mentioned information asymmetries. Is one of the questions that I think that always comes up in investment contract context is whether people are making decisions about their investment based on the managerial efforts of other people. Right. And if there are not any efforts taken by other people, then there are not information asymmetries. Everybody has the same information to operate on. And as we heard end of yesterday, Bitcoin is very neutral. It kind of is what it is. We heard that today as well, right? And I think that could be factoring into the distinction between Bitcoin and Ether.
I want to do a little bit of a thought experiment here, given that it sounds like the Ether ETP is going to be rejected. If they are rejected on the grounds that ETH is actually a security, right, Neel? Can you tell us what that would mean for Ether? I'm not saying that that's going to happen. They could use different grounds. Yeah. But if they should come out and just say that Ether is a security, what's that going to do to Ether and other digital assets like Ether?
I'm going to try to choose my words carefully. I think it would be devastating. I think it would be tough. I mean, it would just roil the markets. I mean, so many things would just be up in the air. Firstly, all the entities trading Ether on a regular basis, platforms trading it would have to become exchanges. Everybody trading it on a regular basis might have to become a broker. But then what does Ether do? It would have to then register. Ether would have to be offers of Ether would have to be registered as securities, or you'd have to find some kind of exemption for them. And then even if you could do that, who's going to be doing the registering? Who are the issuers of Ether at this particular point? And then going forward, like, what do we do about all the Ether that's out there trading already? Like, how do we bring that in? Do the people who bought Ether, do they have some kind of claim against the SEC? It's just going to be completely up in the air. I'll put it as pithily as I can. This is precisely what the SEC typically tries to avoid, which is tremendous disruption to the markets and potentially significant harm to retail investors.
Well, this is going to be fascinating to see how this plays out eventually.
Sure.
Speaking of big legal dominoes, though, there are some out there that haven't fallen yet, right? And in my view, one of the big ones is the Coinbase lawsuit that the SEC has brought. This is a suit that the SEC filed against Coinbase, alleging that Coinbase operates an illegal, unregistered securities exchange, among other things. I guess, going back again to Neel and Dax, and we're going to get to Amy eventually here. Where's that case going? Because there have been some developments. This case has been going on for a while, but there have been some developments.
So I think the Southern District of New York recently rejected Coinbase's motion to dismiss. Essentially, Coinbase tried to dismiss the SEC's case. And I think this is, and the court disagreed. The court said the SEC has pled its case sufficiently. The pleadings are sufficient to sort of make it plausible that you might be an unregistered broker, unregistered exchange, unregistered clearing agency. And this is a significant setback. I don't think there's any denying that. It's hard for me to see what Coinbase can sort of put forward at this, at the merit stage that kind of significantly alters the result. And I think that, it's anyone who's read the decision, it's sort of well-written, it's cogent, it's detailed, and it's hard to see the Second Circuit sort of overturning that. So I think this is a significant setback. But what does that mean? Does that mean I would never bet against Coinbase? There's a lot of litigation left to do, and even if they lose here, even if they lose at the Second Circuit, they will go all the way to the Supreme Court. And I think this particular Supreme Court, which is often very skeptical about administrative agency actions, could be very receptive to a lot of Coinbase claims. Coinbase is making some very sophisticated claims. It's making the claims that many of the assets that it's trading, are not securities, but it's also making the claim that there should be a different framework for these securities. It's kind of a policy claim that it's making as well. And then the final thing I'll say is, let's suppose, as a thought experiment, just carrying this forward, it loses, right? It ultimately loses. Even then, it would have the right to carry on its Bitcoin and Ethereum business, because assuming Ether is not a security, because those are non-securities, and that I think would still be the bulk of its business. So Coinbase is, I would say, despite this very significant setback, still in a formidable position, and I think there's a lot of litigation left to go.
I know, Dax, you've been following that case as well because we talked about it, recently. Do you share that view? I mean, Neel's coming out pretty strong here that Coinbase is just probably going to lose at least at the lower court level, and maybe even at the appellate level.
You may be spotting a little bit of a trend in how I like to riff with Neel here, but I think it's still too early to tell. Right. Too early to call it, right? Really more too early to call it. That this is just a motion to dismiss stage, right? This has not been litigated on the merits. It's just that the judge is just saying, look, the SEC has given sufficient information to convince us that this is a case that should be heard. But now we have to go deal with the merits. We have to deal with the facts. There are lots of open questions around secondary markets. There were only a few assets that were named in the SEC's complaint, right? There's quite a wide variety of the assets that are trading on Coinbase, for instance, right? And so there are legitimate questions that need to be resolved. There's also, I agree with Neel, at the appellate level, there's a lot of disagreement amongst the courts themselves that are ultimately going to need to be harmonized by higher levels of judicial decisions. But one thing that I can say is that to the extent this drags on and we have more litigation against exchanges, secondary platforms, on multi-asset offerings, that the innovators, the companies are just going to move away from the United States, right? This has been a tough regulatory environment on the securities front for a very, very long time, and there is just a real drain on the innovation and the ability to make money as a going concern in this regulatory environment.
Speaking of secondary exchanges, which you just mentioned, it reminds me of the other big legal domino that has yet to fall, and that's the Ripple case, right? Which focuses specifically on whether XRP is a security, right? It seems like in that case, or in some related cases on that topic, the courts can't agree on what the right approach is. I was a little surprised by that in reading, for example, Judge Torres's opinion, one of the first ones that came out. Neel, can you explain what's going on here? Because this is pretty confusing. In fact, it almost represents, to think a lot of other people, that there is not a single way for the SEC to look at this?
Yeah, I think you're absolutely right, Ming, that this has been an area of like judicial disagreement. And it's funny because all three of the judges who are relevant here are in the Southern District of New York. So like in a single federal district, the judges can't agree on what how these secondary trading. How the secondary trading of crypto should be treated. And it's helpful maybe to just set the stage a little bit here and say, the question here is, Judge Torres says, in the primary offering of XRP, people know they're buying from Ripple and they're relying on Ripple's efforts to make a profit for them. So that makes it a security. But when you're buying on an exchange, you don't know who you're buying it from. These transactions are what she called blind bid-ask transactions by often very unsophisticated investors who aren't parsing the marketing or stuff like that very closely. They don't have any expectations from Ripple in the same way, according to Judge Torres, that primary purchasers do. So she says secondary trading of crypto is different and doesn't involve securities. But then you've got Judge Rakoff in the Terra case, which involves Do Kwon, and then you've got recently Judge Faya in the Coinbase decision, and they both take the view that, no, if you look at the amount of marketing that these crypto companies are doing and the kind of marketing they're doing, they're reaching both primary and secondary investors, and so secondary trading of crypto is also securities trading. And so they disagree with Judge Torres. So I think it's inevitable that this is going to go to the Second Circuit and maybe even further, who knows. But so there's a lot left to go in this particular decision, just like with Coinbase. I think you could see it go all the way. And I think the other thing that I would sort of say here is that the SEC doesn't see I think the SEC doesn't necessarily see the Ripple case as being a failure of its theory that secondary trading of crypto is securities trading. They just see it as maybe we couldn't put forward the evidence sufficiently well to convince the court, and we'll fix that at the Second Circuit level. So, again, just to echo Dax, lots of litigation left on this one.
Well, there's clearly still a lot of legal activity, litigation, controversy in the United States around digital assets. But digital assets like Bitcoin are global, right? And it's pretty clear there are other countries out there, the EU, for example, that are really taking a very different approach, right? Dax, I know you've been following that, and you've talked with MicroStrategy a little bit about that. What's happening there, and could the U.S. actually become a much less attractive place for digital assets?
Yes. So the EU now has broad regulatory clarity that the U.S. lacks. The EU developed some legislation, pretty expansive legislation, I think prompted by the Libre Diem project, actually, where in the EU they categorized these different types of assets. And they sorted out these tokens into crypto assets, things like Bitcoin and Ether and what we would have called utility tokens. There are e-money tokens that are meant to be payment tokens that are tied to one fiat currency. This would be like a stable coin like USDC. And then there are other asset reference tokens, which are tokens that have reference to a basket of currencies, either fiat or digital assets. And there are different rules and regulations around each of those, and separating those from, or distinguishing those three from really financial instruments, which are regulated securities. And there's a much more narrow definition of a security in Europe, and frankly, most places in the world outside of the US and Canada. And so that big drag that we have of the securities issues in the United States is resolved in the EU, right? And so that does make the US less attractive. We have clarity on probably most other issues that relate to digital assets in other areas like commodities, for instance, money transmission, but we don't have it on the securities front. And so that does lead to, I think, like jurisdictional selection, where innovators and businesses who are hiring people and launching products get to go forum shopping for some place that's friendly for them. And that may not be the United States, but it's just worth noting that in the United States, like, this is the largest market. And so projects may launch outside the United States, where they are going to need to come back in. Even those projects launched overseas should be taking into account U.S. laws because they ultimately want to end up back here.
This was a great discussion on some of these large-scale legal topics. I want to switch for a bit to accounting, where similarly a big accounting domino fell in December when FASB issued new rules that changed the accounting treatment of certain crypto assets like Bitcoin, right? I know, Amy, you talked a little bit about that last year at this panel, or the equivalent panel from last year. Can you briefly describe the changes that occurred and tell us your assessment of the significance of it?
Yeah, happy to, Ming. And you say a domino fell. I have little kids, so I'm seeing hearts and rainbows and balloons because this is a huge win for the digital assets industry. And you can see the smile on my face. Last year, I was like half smiling because we got a little bit of a preview, but this is great news. And usually when I used to talk to companies about the current accounting model, pre this new accounting model, like I felt like I was booed off the stage. People wanted to throw rotten tomatoes at me, but now I have some good news to share. And so the big headlines here is fair value. And I think what's important to really understand why this is so significant and why it's a huge win is to really understand what today's model or what the old model was like. And so when you're looking at the accounting rules, you have to kind of go by the definitions to say, where does something like holding Bitcoin fall within the definitions in the accounting guidance? And so you look at things like cash equivalents, it doesn't meet the definition of that. Financial instrument, it doesn't meet the definition of that. Inventory actually in accounting rules need to be tangible. This is not tangible. So you almost defaulted to an intangible asset. And you're kind of like, well, when I think about accounting intangible assets, I'm like IP, customer lists, patents. I don't think about something like Bitcoin. And all of those things that I named before, you don't actually actively trade and exchange that, right? It's usually held on your books for a while. And so you are stuck in this model where it's an indefinite lived intangible asset. It doesn't have any life to it. And so you have to account for it at the cost that you acquired it at, which hopefully is fair value on day one. And then you have to assess it for impairment. And what does that mean? That basically means what I hold it at. If the fair value is something lower, then I need to constantly write it down. But I can never write it up. So let's just take some basic numbers, and I wrote these down so I can remember. But January 1, 2024, and I'm going to round here because we can round with Bitcoin. The Bitcoin price was around 44,000. So let's say I bought it on January 1 at 44,000. DAX decides to buy it on March 31st, 2024. The price was 71,000. So he paid 71,000, I paid 44,000. Well, between January and March, the price went down to as low as around 38,000. So on January 1st, I recorded at 44,000. And then when it went down to 38,000, I had to write it down to 38,000. And then it comes time for my Q. I'm a calendar year end. So my first quarter 10Q, 331. I'm reporting it at that 38,000, my one Bitcoin. DAX reports it at 71,000. If we were to both try to sell it on that same day, we would probably get the same fair value. But on my books, it's at 38. On his books, it's at 71. And so for an asset that's actively traded like Bitcoin, companies were having a really hard time with, man, you got to keep monitoring. And let's be real, right? The price doesn't stay flat. It goes up and down. So you have to keep monitoring to see what the price is. Has it gone down? I have to keep writing it down. Will it recovered? Sorry, you don't get to get the recoveries until you actually sell. And so what we had was a model that really didn't reflect the economics of what you were holding or your asset. And so when you think about financial statements from an accounting lens, you always want to know, it should tell you the economics of what you have, your assets and your liabilities. And it was really, really difficult for people who were, trying to read financial statements to say, well, Amy and Dax, they both hold one Bitcoin. They don't necessarily know that I bought mine on January 1st and that he bought his on March 31st, but his looks so much more valuable than mine. But in reality, it's not. And so that's why the current model was really, really broken, and why now, if we move to fair value, on 331, both of our financial statements will have something roughly around the 71,000. So it's a huge win. it makes the burden on preparers or companies who are putting together their financial statements. A lot of companies who hold Bitcoin had to do one set of books for financial statement and accounting reporting purposes, and then another set of books to talk to their investors of like, well, no, this is what it actually is. And that duplicative nature was just really burdensome, really costly. Like I said, for investors, it was very difficult to really understand. And so this is a huge win. The new ASU came out in December of 2023, so it just came out. It's effective for companies that have a calendar year end in 2025. So it actually has a pretty long effective date. And the FASB does that intentionally because maybe some companies, it takes some time to put together the processes or whatnot. They want to give companies time to actually adopt new accounting standards. But you could early adopt it. So we have seen some companies out there. I think Salmon today from Marathon had talked about their company or his company early adopting. And so you'll see some companies that are now starting to report their digital assets at fair value. A couple of things, though, that I want to highlight. So the FASB was really, really quick in getting the standard out. But because they were quick, they couldn't necessarily put everything in. And so there will be some challenges, particularly related to scope, of like, are you in the scope of this new standard or not? For things like Bitcoin and Ether that we're talking a lot about today, those are all in. But when you start getting towards other assets like some of the ones that Dax just mentioned, the wrap tokens, utility tokens, I mean, there's going to be a lot of judgment in terms of figuring out, okay, should those be in or should they not be in? And again, the difference of being in or out of scope of this new standard is going to be pretty significant. I also want to say there's no such thing as a free lunch ever, though I think somebody today earlier said that there was something that was a free lunch. But there's no such thing as a free lunch here. Everybody wanted fair value. That's what you got, but it also comes at a cost. There's a lot of extra additional disclosure requirements that are now going to be required. And the reason behind that is a lot of the investors that basically gave feedback to the FASB said, it's really hard for me to understand what a company is doing related to their digital assets with the current intangible asset guidance and the current intangible asset disclosures. And so the FASB put in a lot of additional disclosure requirements. Companies are going to have to disclose a significant holdings table. So basically, if I hold Bitcoin and Ether, I can't just lump that and say, these are my digital assets. I have to actually show I hold Bitcoin, I hold Ether. You have to do a reconciliation. You'll still have to show your cost basis, your ins and outs. So there's a lot of additional extra disclosure requirements. And I think you'll see a lot of companies were really excited about, hey, I get to do fair value. But one of the things that I've been talking at least with many of our clients was, think about these disclosure requirements. Do you have the right data and the processes in place to make sure that you have, you will be able to comply with these requirements, et cetera. And for a company that, like MicroStrategy, that holds one digital asset or one digital asset type, it may be easier. But if you think about some of the other companies that maybe hold many, many different types of digital assets, being able to get that information is going to be really, really critical. Some of the other highlights, though, I think that's interesting, Ming, is that by moving towards fair value, the FASB wasn't necessarily changing the nature of the asset. They still believe that it's an intangible asset. So it's not a financial instrument just because we're moving towards fair value. It's an intangible asset that now is being accounted for different than other intangible assets. So in the actual FASB guidance, it still falls within the intangible asset guidance. That actually is one of the criteria to be in scope. It has to be an intangible asset. And you have to present it separately from your other intangible assets, which makes sense. And so those are some of the things on the accounting side that's, I think, super exciting and a great win for the digital asset industry.
That was a very good explanation of the rule change, and I liked the numerical example that you gave. Let's probe a little bit further. Are there other things that can interplay with this new FASB guidance that people just need to keep in mind?
Yeah, so one of the things that the FASB did was they said you have to account for these assets at fair value, but they didn't create a new fair value methodology. They went with existing fair value. And a large reason of that is like, you don't want to create anything new necessarily. And then two, in order to get this guidance out as quick as they needed to, they basically had to default to the current existing fair value guidance. But digital assets are slightly different. And so when you think about fair value, there's some additional nuances that you're going to have to think through. And it's not necessarily that evident when you're just thinking about traditional securities. So for example, you have to account for it at fair value based off of your principal market. That's the terminology that the accounting guidance uses. Well, for something like a security or a stock that's traded on one exchange, for example, like the New York Stock Exchange, you're going to go to fair value based off of the New York Stock Exchange price. Well, for Bitcoin and crypto, multiple exchanges. And so you have to actually go, and you can't have a rate, you can't have multiple exchanges as your principal market. It really needs to be one. And so you have to actually think through what is your principal market. So if Dax is a company, his principal market may be different than my principal market. Another thing is crypto never sleeps. I think we just heard 24/7, right? And so, traditionally markets close, for securities at a certain time, 12/31, everybody's cutoff is the same time. But if you have crypto markets that go 24/7, is your cutoff at 5 p.m.? Is it a UTC time? So even 3/31, I said 71,000. Well, if Dax's cutoff is 7 p.m. and mine is 4 p.m., that could be a different number. So there's additional nuances that you have to think through, particularly around fair value. And the other thing I always like to say is, I'm certainly not a tax expert, but I also know that taxes related to digital assets and accounting don't all necessarily jive, the tax rules, right? And so there are book-to-tax differences that companies are going to have to think through. So unrealized gains and losses versus realized gains and losses, those usually create book-to-tax differences. That concept of principal market that I just talked about, tax rules have a completely different rule. They actually, I believe, look to aggregators, so look to multiple different price points to come up with what your principal market is. So that could be different depending on what the volatility is of market-to-market pricing. And then also how companies, when they're early adopting, when you adopt the guidance, you have to account for basically any change from what you had it on your books to the 1/1 beginning of the fiscal year price, and that all goes to retained earnings. And so as companies think about the new corporate AMT rules, that could potentially have an impact on how those unrealized gains or losses are potentially maybe triggering a corporate AMT or maybe not triggering corporate AMT. So I always say accounting and tax with crypto, you need to think about those two and make sure that you have those straight, because they may not all the time be the same.
That's such a great and helpful explanation. I'm hoping we can fit in one more accounting topic here. I know we're a little bit tight on time, and that's SAB 121. It's been getting a lot of press, including in Congress. Can you explain what that is briefly and why it's controversial? Touched on earlier today in some of the presentations.
We talked about it a little bit earlier today. So SAB 121 came out in March of 2022. It basically was a staff accounting bulletin from the SEC that says, if you are a company that is safeguarding, and I'm going to air quote that, crypto assets on behalf of somebody else, you now need to record a liability that's going to be recorded at the fair value of those crypto assets, with a corresponding asset that takes into account whether or not maybe those assets have been lost or loss events. What's really important, Ming, to understand, and I think Alex talked about this earlier today, is that this was issued by the SEC as a staff accounting bulletin. So SAB is staff accounting bulletin. Mm-hmm. That means it wasn't an SEC rule. It didn't go through their normal rulemaking process. And I see Neel shaking his head, so what I'm saying is right. It's all it is a staff interpretation. And so it wasn't issued by the FASB either. And so it's a staff interpretation, but where we struggle is if your regulator tells you that this is how they are interpreting the accounting rules, it probably behooves you to follow what your regulator is telling you. Otherwise, your regulator will probably say, well, your accounting is incorrect. And so there's a little bit of noise out there, or maybe a lot of noise out there about, was this, the legitimacy of this, et cetera. But at the end of the day, it was a staff accounting bulletin that gave a pretty big change, I will say, to the accounting of companies that were potentially safeguarding. And I'd say that because before the SAB came out, most companies had to think through, do I control those assets? If I control those assets, those customer assets, for example, then they're on my books. If I don't control them, then they're off the books. Well, this is saying whether or not you control doesn't matter. You have to think through whether you're safeguarding them. And if you're safeguarding them, it's not that those assets come on your books. You have a safeguarding asset and liability on your books. Happens to be measured at the fair value of what those assets are. But that's a pretty big change. Like you may say, well, asset equals liability, net zero. Why does it matter? But I think Alex talked about it pretty well this morning of, well, for certain entities, particularly regulated entities, it actually does matter. The gross up is a huge impact, particularly to regulatory capital. And so I think a lot of companies that were potentially thinking about moving into the space and trying to enter into some type of business where they were providing those types of assets or those types of capabilities to their customers were now almost prohibited from being able to do that because they may not be able to make some of their regulatory requirements. And so huge impact to the industry. I think we've seen as a result of that, many companies that were thinking about entering have basically stopped. And I think, well, there's probably more to come there. But the SAB itself doesn't actually define safeguarding. But our understanding is that the SEC has very broadly interpreted that. And the AICPA Digital Assets Working Group, of which I sit on, has issued some Q&As that basically are a result of direct conversations with the SEC staff about how they would think SAB 121 should be applied. So that's a helpful thing to look through if SAB 121 is potentially relevant to you or your company.
This discussion reminds me that there are some significant legal considerations on the operational side, for businesses that want to develop or launch Bitcoin, related applications or business lines. So I'd like to talk about that side, that is companies wishing to either start or conduct Bitcoin-related businesses, because there are considerations there that are important. Dax, you've been in sort of this space for a very long time. And so let's first start off just very briefly. Tell people what sort of use cases you're seeing as a legal practitioner, and then we can get into some of those main legal considerations. Sure.
So here's the use cases that I'm seeing, Ming, that really excite me. One is layer 2 applications that are built on the Bitcoin layer 1 blockchain, things like Lightning. Lightning excites me as a payments and technology lawyer with what it can do. If you were here yesterday, wow, everyone should be looking at Lightning and what is your Lightning strategy, no matter who you are. Another one is Bitcoin ordinals. We've seen non-fungible tokens, NFTs, really in the Ethereum space and some other Solana and other blockchain smart contract type situations where we need tokens that are not all fungible, that can be a unique asset, a collectible, a title certificate. And there has been innovation around the Bitcoin blockchain that approximates the functionality of NFTs for tracking of non-fungible assets. I've seen a lot of innovation around wallets, especially like non-custodial wallets, and how those wallets might interact with other real-world financial services infrastructure. And then lastly, just leveraging the Bitcoin blockchain as the most trusted source of truth and common ledger for things like identity verifications for individuals or identifying devices or wallets.
So if you're a company that's wanting to start up a Bitcoin, say, related business line, what are some of the main legal considerations that you see? And this is going to segue eventually into what I understand is an increasingly challenging environment for companies that want to do that.
Sure. I mean, there's a punch list for me that first is go look at the regulatory requirements and figure out if what you're building touches on securities, commodities, money laundering, money transmission, anti-money laundering, or sanctions laws. You got to just scrub those for sure. There's other issues that can come up, but that's the table stakes. And then just to figure out when you're building applications, are you doing certain activities that are regulated, or are you partnering with service providers that are doing the regulations? And in many instances, you might just be building a solution that leverages the services of a regulated entity. And so many times those responsibilities can be outsourced, but I will just tell you that it is harder to sort those responsibilities than you might think when you get into the very powerful and flexible technologies around like wallet maintenance and running nodes, for instance. Those lines get kind of blurry, but you need to make sure that someone's clearly minding the store. There's intellectual property issues. There's things like patent litigation, like MakerDAO, for instance, is dealing with patent litigation. How does a decentralized autonomous organization appear in court to defend itself from allegations of patent infringement? On the money transmission side, right now we have some really fascinating questions that also start to bleed into another core issue of just like developer liability, where we have Tornado Cash and we have Samurai Wallet, where the DOJ, Department of Justice, has gone after and arrested and seized properties related to non-custodial wallets that also have some privacy features that in these cases were promoted as helpful for criminals, right, mixing services, but nonetheless, these are non-custodial wallets in many cases. And so, but yet there's allegations it's money transmission. Well, there's the black letter law in the Bank Secrecy Act. You have to be receiving money and transmitting it to another person or location for it to be regulated. Yeah, but yet we have a pretty overly broad assertion here on the money transmission side. So those are some of the issues to figure out. And then once you have a product, to like draft clear terms of service and privacy policies, how all these things work. Often when there is not a centralized account, you turn up a lot of these kind of norms on their head. Lastly, Ming, I'll just note that when it comes to, though, just Bitcoin, if you're just holding Bitcoin on your treasury, for instance, many of these regulatory issues that I've raised just don't apply. That those are your custodians, your brokers are going to be dealing with those issues, and you wouldn't be tripping into money transmission or licensing or need a BIT license for many of those activities. Right,
so you don't have to directly take on a lot of those responsibilities, but you do need to then select your partners and your vendors very carefully, right?
That's right.
I want to follow up here near the end on something that you've mentioned to me recently, which I found a little bit surprising and runs a bit counter to the positive clarification that has occurred on the accounting side and with respect to the approval of the spot Bitcoin ETPs, and that is that the regulatory environment for businesses that are interested in, or companies interested in starting some kind of a Bitcoin, say, application business, is actually getting tougher in some ways. In fact, you told me that just getting crypto businesses banked is an increasing challenge. Yeah. How can this be? Why is this happening?
Well, I mean, we're in the midst of a crackdown on banks who are supporting crypto businesses and fintechs. In many ways, it's a little deja vu back to 2014 when there was regulatory clarity, but the banks weren't yet comfortable banking digital asset businesses. Many of the digital asset business, even though you may be focused on Bitcoin, you still need to have some TradFi partners. You may have operating accounts and you need to make payroll. So you need bank partners. But the bank regulators, the Office of Comptroller of the Currency, the Federal Reserve, the FDIC is increasingly finding problems with how many of the banks, and often they're smaller, maybe community banks, are supporting these fintech and crypto businesses that are honestly struggling to deal with the onboarding and the customer verification and monitoring. And so these banks are receiving pretty onerous enforcement actions. And that's going to really cool their ability and their willingness to bank these companies that may be developing in Bitcoin and other digital assets. And then, Ming, since we were here last, we have some major banks that have just failed. Silvergate Bank, that was a major player for crypto businesses, is gone. Silicon Valley Bank, gone. Signature Bank, gone, right? And so there's just fewer banks all around. And this audience, I'd say the people who are developing in Bitcoin need BlackRock-like banks. I mean, not that BlackRock is going to be banking them, but banks that offer bank accounts, retail accounts, and others, operating accounts, that are willing to get into this space to help support them.
It was kind of like just as there was a BlackRock moment, so to speak, when it comes to the ETPs, right? Yeah. You're saying something like that is really needed on the banking side.
Neel, what are you seeing in this space?
I think I completely agree. I mean, we're in the traditional securities industry, TradFi, banks and broker-dealers have really been critical towards like good custodial practices, and that's sort of what encourages institutional adoption of an asset. When you know that you've got a safe custodial sort of setup in place, and I think that is just highlighted in its absence in crypto. So, the SEC has made it very, very difficult for broker-dealers to hold crypto. I've seen, although I'm not a banking lawyer, I've seen sort of similar difficulties on the banking side. We've seen Custodia recently with, the Wyoming federal courts failing to get a master account. And so I think, until we get a custodial solution sorted out with banks and broker-dealers, institutional adoption of crypto is going to be hindered or delayed. And now the SEC has proposed a safeguarding rule. It's kind of useful because it talks about what the conditions are under which investment advisors, in particular, can sort of hold crypto for their clients. But I think what the piece that misses is investment advisors may need to hold crypto for their clients in certain ways, but is the infrastructure in place to have that actually happen? And I'm not sure that the SEC actually sort of has fully assessed the landscape and the options that are available. So until that big piece gets sorted out, I think institutional adoption of crypto is going to be challenged.
Very quickly before we end, because what you just said is you've highlighted a bunch of challenges, right, in this environment. What is your sort of best piece of advice then for digital asset businesses in dealing with banks and custodians? Because we've got to offer somebody some guidance here.
I guess I'd just say customer beware, know your partners, know who's holding your money, your assets, ask good questions. There are many fiduciaries or entities that should have had fiduciary obligations. FTX and Sam Bankman-Fried, who's now got 25 years in prison. Prime Trust that went into receivership and then bankruptcy because of, frankly, I think like mismanaging of keys to Bitcoin. Like these entities are supposed to be fiduciaries. Some of the early ones, really didn't have the right sort of controls. I'm not equating necessarily FTX to these entities that are here in the audience. I'm not, for sure. But these are entities that are custodying your assets. I mean, these are the crown jewels. And so ask a lot of questions, find out about audits, understand the security controls that they have in place, have an ongoing dialogue. Just expect to be part of that conversation around regulatory controls, understand where they are with their regulators, if they're receiving subpoenas and enforcement actions. Just treat them like good partners and expect them to be good partners too. And I'll just note that for the practicalities are that many of the custodians in the Bitcoin space are also just dealing with a large insurgence of interest in their services, and they are becoming more like some of the traditional custodians with securities. And so they're trying to formalize their operations and their contracts. And so there's just necessarily little dance that goes on the allocation of liabilities and responsibilities here. And so these will just take sophisticated conversations to try to find the right place. But at the end of the day, these are custodians that are watching your money. That's what they sign up for. And I think that the customers should expect that the custodians and partners and your bank partners will deliver and safeguard your assets.
This reminds me to remind everybody else that MicroStrategy has done a large amount of learnings on those types of issues, legal issues, diligence issues. And we have open sourced a large deal of the materials that reflect our learnings. And you can find it on our Bitcoin Corporation's website. Just go there, it's at the bottom of the page. It includes For example, our Bitcoin trading policy, our Treasury Reserve policy. I think there's a checklist for how you deal with vendors and exchange service providers and custodians. It could be very helpful for people who are looking to start or conduct some sort of a business, Bitcoin related business line. So with that, I want to thank our panelists for this discussion. We're unfortunately out of time, but if you have any other questions for us, obviously talk to our experts, come find me. You can look for us after the conference. And I want to thank our presenters again for being up here and providing such insightful guidance. Thank you.
Thank you.
Thank you so much.